E. Jury trial demanded. Complaint for rape, sexual misconduct, criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, false imprisonment, and defamation. And in my experience, someone's not going to file a lawsuit like this that's not accurate, because first of all, you can get in a lot of trouble. And yeah, they would have sued her already if it was made up. They would have totally sued her, and she'd be in jail for it, in my opinion. So here we go. Plaintiff Jane Doe, proceeding under a pseudonym, and this is from somewhere around 2016. It's probably, the date is probably written at the end of it. Oh, it was filed on September 30th, 2016. Okay. Brings this action against DJT and JEE that alleges that, one, plaintiff is an individual residing in and citizen of the state of California. Two, upon information and belief, defendants DJT and Jeff EE, I'll just say little d and little e, each reside in the district and are citizens of the state of New York. Jurisdiction and venue. Plaintiff is a citizen of the state of California for the purposes of diversity jurisdiction. 4 defendants are citizens of the state of New York for purposes of diversity jurisdiction. This court has original subject matter jurisdiction with respect to this action, pursuant to, as there exists complete diversity of citizenship between plaintiff and defendants, and the amount in controversy exceeds $75,000, exclusive of interests and costs. Defendants are each subject to the jurisdiction of this court pursuant to, with proper venue pursuant to. I'm not going to read you all those letters and numbers. It's kind of meaningless to me anyway. If you're a lawyer, I guess you could read along because the link is there in the description if you're interested in that stuff. As both defendant, I'm going to just kind of brush over a lot of this that's kind of plain vanilla information. As both defendants are residents of and or domiciled in the district, and the events giving rise to the claim occurred in the district. And then this section is titled Rape, Sexual Misconduct, Criminal Sexual Act, Sexual Abuse, Forcible Touching, Assault, Battery, Intentional and Reckless Infliction of Emotional Distress, Duress, and False Imprisonment. Number 7, plaintiff was subject to acts of rape, sexual misconduct, criminal sexual act, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, duress, false imprisonment, and threats of death, and or serious bodily injury by the defendants that took place at several parties during the summer months of 1994. The parties were held by defendant little e at a New York City residence that was being used by defendant little e at 9 East 71st Street in Manhattan. That's that largest, most expensive residence in Manhattan. It's like 7 stories. And apparently Les Wex bought it for him. Might have sold it to him for like $1 or $10 or something like that. Allegedly, I came across that information the other day. I think it was $10. During this period, but it's like a $10 million place, I'm sure. During this period, plaintiff was a minor of age 13 and was legally incapable under New York law of consenting to sexual intercourse and other sexual contacts detailed herein. The rapes in the first, second, and third degree sexual misconduct and criminal sexual acts in the first, second, and third degree sexual abuse in the first, second, and third degree, and forcible touching, and on information and briefing, predatory sexual assault. Let me just say here that I found this with a very simple Google search. I can tell you the exact words that I put in the search engine. It was grape, Jane Doe, and the last names of little t and little e. I think that was all I put in there. And this and a whole lot of other stuff came right up. And that was Google, not Yahoo. Yahoo, I think, is like owned by people that scrub everything. Like Yahoo doesn't pull anything up, in my experience. Let's see. Where was I? Sexual assault detailed herein are unlawful under New York law and continue the torts of assault, battery, false imprisonment, and intentional or reckless infliction of emotional distress, including threats of force and serious bodily harm under New York law. In addition, the U.S. Code provides plaintiff with a civil remedy for personal injuries because plaintiff, while a minor, was a victim of violations and she suffered personal injury as a result of such violations. Declaration of Plaintiff Jane Doe, Exhibit A herein. Declaration of Tiffany Doe, Exhibit B here too. Declaration of Joan Doe, Exhibit C here too. Jane Doe, Tiffany Doe, and Joan Doe are each pseudonyms as each woman wishes anonymity. Oh, and I heard an interview. Trying to remember who did the interview. It wasn't Connie Chang. I'll look it up. I'll put it in the description. It was with Jean E.G. Carroll. Is that her name? The one from the lawsuit with the Bergdorf and Goodman dressing room assaults. E. Jean Carroll, right? Anyway, it was a really good interview. I was listening to that while I was getting the house pulled together for the guests that are coming, the day after tomorrow? Yikes, I'm running out of time. I still have things I need to do. Today is day 4 of the deliberation. No, I did not see that about Los Angeles and Maui. Isn't that insane? Thank you for keeping me abreast of the Karen Reed trial. That is one I'm super interested in. It's just that I'm so hyper focused on the political stuff, and I guess I get my true crime fix from the politics because there's so much criminality going on right now. So many crimes being committed left and right. It's atrocious. Where was I? The anonymity. Tiffany Doe, a witness, was an employee of defendant little e, Exhibit B. Joan Doe, a witness, was a childhood classmate of plaintiff who, in the 94-95 school year, was told by plaintiff that plaintiff was subject to sexual conduct by the defendants at parties in New York City during the summer of 1994. So here we are, this lawsuit 22 years later. Courts have discretion, and this is the second time she filed it. I think I already said that. Excuse me. Courts have the discretion to allow proceeding anonymously where the need for privacy outweighs the public's interest in knowing their identity and any prejudice to the defendants. Sealed plaintiff versus sealed defendants. This litigation involves matters that are highly sensitive and of a personal nature, and identification on plaintiff would pose a risk of retaliatory physical harm for her and to others. Exhibit A. All of the 10 factors that the Second Circuit articulated as relevant to the analysis favor anonymity, especially factors 1 through 4, 7, and 10. Factors 1 and 2, whether the litigation involves matters that are highly sensitive and of a personal nature, and whether identification poses a risk of retaliatory physical or mental harm to the party seeking to proceed anonymously. So yeah, I wanted to say too that I've learned my lesson to not try to print things out and read them to you, because it is always so whack. Like there's always parts missing, pages out of order. I would take responsibility for it, but I don't think it's me. I think it's the printer. But I guess it's me because I don't know how to print right. Okay, I'll take responsibility for it. It's all my fault. Like that Kurt Cobain song, all apologies. Everything's my fault. Okay. Retaliatory physical or mental harm to the party seeking to proceed anonymously, or even more critically, to innocent non-parties, or are neutral with respect to anonymity. Protecting plaintiff's anonymity is also appropriate, as she is a rape victim. Plus, she was a child rape victim. Number 9, plaintiff was enticed by promises of money and a modeling career to attend a series of parties with other similarly situated minor females held at a New York City residence that was being used by defendant Jeffrey E., little e. At least 4 of the parties were attended by little t. Exhibits A and B. On information and belief, by this time in 1994, defendant little t had known defendant little e for 7 years. I've known Jeff for 15 years, terrific guy, quote unquote. Little t booms from a speakerphone, quote, he's a lot of fun to be with. We've all heard this quote a million times. It is even said that he likes beautiful women as much as I do, and many of them are on the younger side, no doubt about it. Jeffrey enjoys his social life. It's like a pretty pathetic social life, if you ask me. And that's not a social life. That's called a sex life. Social life is like being social. It doesn't involve getting physical. It's social. Freak. Okay. End quote. And knew the plaintiff was then just 13 years old. Exhibits A and B. See, you can't file a lawsuit without having your evidence. You know, no lawyer is going to file a lawsuit without evidence. And any judge that thinks that you're just like wantonly filing a lawsuit for the heck of it, they'll hold you in contempt of court. But like I said, these defendants, little t and little e, they would have slapped her with a $100 billion lawsuit immediately. Like they would have countersued immediately before she even withdrew it. But especially after she withdrew it, because they'd be like, see, she withdrew it. That's evidence that it's fake. It's like, no one's going to put this out there 22 years later for shits and giggles, in my humble conspiracy theory opinion, allegedly. Okay, number 10, defendant Trump initiated sexual contact with plaintiff at 4 different parties. Little t, sorry, Trumpster fire. Bleep. Okay. On the 4th and final sexual encounter with little t tied plaintiff to a bed. I mean, this does sound unbelievable, in my opinion. But like I said, I think that she would have been held in contempt of court if this wasn't true and accurate, and they would have gone after her big time. They did go after her with threats to her safety, so that's why she withdrew it, in my opinion, and that's what she says, allegedly. Defendant little t tied plaintiff to a bed, exposed himself to plaintiff, and then proceeded to forcibly rape plaintiff during the court. And let me do the trigger warning again retroactively if this is triggering. Don't listen, don't watch. log off, take care of yourself. During the course of this savage attack, it says savage sexual attack. I'll just read most of the words. Plaintiff loudly pleaded with defendant little t to stop, but with no effect. Defendant little t responded to plaintiff's pleas by violently striking plaintiff in the face with his open hand and screaming that he would do whatever he wanted. Exhibits A and B. See, honestly, I find that hard to believe, but there's exhibits. We'll see if they're in here at the end. I like browsed through it, but I didn't go through it with a fine-tooth comb yet. That's what I'm doing right here, right now with you. It's very alarming, the hitting in the face. But yeah, if you're going to do all the rest of this stuff to a 13-year-old, like, where is the line in the sand? Like, what won't you do, right? And I'm surprised that they didn't unalive her for ratting them out. They threatened to, at least that's what it says in here. Hold on. Number 11, immediately following this grape, defendant little t threatened plaintiff that were she ever to reveal any of the details of the sexual and physical abuse of her by defendant little t, plaintiff and her family would be physically harmed, if not killed. Exhibits A and B. Defendant little e had sexual contact with plaintiff at 2 of the parties. The second sexual encounter with defendant little e took place after plaintiff had been graped by defendant little t. Defendant little e forced himself upon plaintiff and proceeded to grape her, trigger warning, anally and vaginally, despite her loud pleas to stop. Defendant little e then attempted to strike plaintiff about the head with his closed fist while he angrily screamed at plaintiff that he, defendant little e, rather than defendant little t, should have been the one who took plaintiff's virginity, before plaintiff finally managed to break away from defendant little e. Exhibits A and B. The threats of violence against plaintiff and her family continued, this time from defendant little e, who again reiterated that plaintiff was not to reveal any of the details of his sexual and physical abuse of her, or else specifically plaintiff and her family would be seriously physically harmed, if not killed. Exhibits A and B. 14, while still under threats of physical harm, by coming forward and having no reason to believe that the threats have ever been lifted or would ever be lifted. And you got to remember, Virginia Giuffre dealt with these threats relentlessly throughout her entire life. Plaintiff, who has suffered from stress, emotional distress, mental pain, and suffering, among other problems, ever since the assaults, was subjected to daily painful reminders of the horrific acts of one of the perpetrators. Defendant little t, via mass media coverage of him starting on or about June 16th, 2015, that over a short period of time became continuous and unavoidable. Exhibit A. And that's probably like the day that he went down the escalator announcing his candidacy to run for the Republican ticket. The anniversary of that, 10-year anniversary of that, just passed like 2 days ago. Number 15, as a direct and proximate result of the sexual assaults and grapes perpetrated by defendants upon her, plaintiff has suffered stress, emotional distress, and mental pain and suffering, as well as adverse physical consequences. Hola, Fred Field. How are you today, sir? Nice to see you. Thanks for coming in. I'm reading the lawsuit that Jane Doe filed twice against little e and little t and withdrew twice. It's from 2016 was when it was filed. I think she withdrew it in 2017. I'm about halfway through the lawsuit. As a direct and proximate result, this is number 16, as a direct and proximate result of the sexual assaults and rapes perpetrated by defendants upon her, plaintiff has suffered physical pain and suffering. Number 17, as a direct proximate result of the sexual assaults and rapes perpetrated by defendants upon her, plaintiff has been subjected to public scorn, hatred, and ridicule, and has suffered threats against her life and physical safety. 18, as a direct and proximate result of the sexual assaults and rapes perpetrated by defendants upon her, plaintiff has incurred special damages, including medical and legal expenses. 19, the sexual assaults and rapes perpetrated by defendants upon plaintiff were intentional acts. 20, the conduct of defendants demonstrates willful, reckless, and intentional conduct that raises a conscious indifference to consequences. See, because both of them never suffered any consequences of their actions. They both got out of everything. I think that little E thought he was going to get out of the last one without any trouble, but then I think that he became unalive, and I don't think by self. I think it's interesting who was in charge of the nation at that point in time. August 10th, 2019. And who was the Attorney General, William Barr, whose father, is his name Donald Barr? I forget his father's name, who had hired little E back in the 70s to be a teacher at a high school in New York. Anyway, William Barr should have never had any, he should have recused himself from anything little E, but he never did. He was all in, hands on deck, all hands on deck. Let's see. At the appropriate time, this is 21, in this litigation, plaintiff shall amend her complaint to assert a claim for punitive damages against defendants in order to punish defendants for their action and to deter defendants from repeating their conduct. Tolling of statute of limitations. 22, any statute of limitations applicable to rape, sexual misconduct, and criminal sexual acts, sexual abuse, forcible touching, assault, battery, intentional and reckless infliction of emotional distress, false imprisonment of a minor, if any, is told owning to the continuous and active duress imposed upon plaintiff by defendants that effectively robbed plaintiff of her free will to commence legal action until the present time. More particularly, plaintiff was unrelentingly threatened by each defendant that were she ever to reveal any of the details of the sexual and physical abuse caused to her by defendants, plaintiff and her family would be physically harmed if not killed. The duress has not terminated and the fear has not subsided. The duress is an element of or inherent in the underlying causes of action complained of herein. The duress and coercion exerted by defendants has been such as to have actually deprived plaintiff of her freedom of will to institute suit earlier in time, and it rose to such a level that a person of reasonable firmness in plaintiff's situation would have been unable to resist. Exhibits A and B. And let me just clarify that I'm under the impression that this is the second time that she filed this lawsuit, but perhaps this is the first from the way it reads. But either way, she filed it twice, she withdrew it twice. Number 23. Did I finish all of that? I think I finished it. And it rose to such a level that a person of reasonable firmness in plaintiff situations would have been unable to resist. Exhibits A and B. 23. Both defendants let plaintiff know that each was a very wealthy, powerful man and indicated that they had the power, ability, and means to carry out their threats. Indeed, defendant little t stated that plaintiff shouldn't ever say anything if she didn't want to disappear, like Maria, a 12-year-old female that was forced to be involved in the third incident with defendant little t. That's the first time I'm coming across the part about Maria, 12-year-old female. And that plaintiff had not seen since the third incident, and that he was capable of having her whole family killed. Exhibits A and B. 24. The duress has prevented plaintiff from starting litigation before this year. However, as soon as she surfaced, she received threats. More specifically, shortly after her first complaint was filed in California on April 26, 2016, she started receiving threatening phone calls on her cell phone. Exhibit A. 25. Defendants are equitably estopped. I've never seen that word. Equitably estopped from arguing that any statute of limitations has not been toiled, as defendants wrongfully forced plaintiff to refrain from timely commencing this action by threats, duress, and other misconduct. Exhibits A and B. A wrongdoer should not be able to take refuge behind the shield of his own wrongdoing. 26. Moreover, this action has been brought before the facts, giving rise to the estoppel. Sorry, my glasses. I don't know that word. ESTOPPEL. Giving rise to the estoppel have ceased to be operational, i.e., while still under threats of physical harm, by coming forward and having no reason to believe that the threats have ever been lifted or would ever be lifted. And since plaintiff has decided to seek redress at this time, plaintiff seeks an order of protection in favor of plaintiff and all associated with her, as to protect them from harm and harassment from defendants and their agents and associates. Exhibit A. Defamation. 27. On information and belief on or about April 28, 2016, defendant little t provided the following statement to American Media Incorporated and or Radar Online LLC for publication on at least their website, radaronline.com, regarding plaintiff's complaint filed in the U.S. District Court for the Central District of California. Quote, the allegations are not only categorically false, but disgusting at the highest level and clearly framed to solicit media attention, or perhaps are simply politically motivated. There is absolutely no merit to these allegations, period, end quote. I mean, that's standard. That's what anybody always says in a situation like that, unless they're going to admit it, which doesn't typically happen. Or it's just a big misunderstanding, right? I thought it was consensual. It's just a big misunderstanding. I thought she was 21. It's just a big misunderstanding. The statement provided for publication by defendant t was published by said website and has been republished elsewhere in whole and in part numerous times, and similar statements of an attorney for defendant t were also published, including on September 22nd, 2016 by Courthouse News Service. So that was right before the election. The statements provided for publication by, remember, he was having all kinds of legal trouble right before the election. The first election that he was a candidate in 2016. The statements provided for publication by defendant t and his agent that were published by said websites are false as they pertain to plaintiff. 28. The published statements are libelous on their face and clearly expose plaintiff to hatred, contempt, ridicule, and oblique. Ridicule and oblique, is that what that word is? OBLOQUY. 29. As a proximate result of the above described publications, plaintiff has suffered loss of her reputation, shame, mortification, and injury to her feelings, all to her damage in an amount to be established by proof at trial. The above described publications were not privileged because they were published by defendant t and his agent with malice, hatred, and ill will toward plaintiff and the desire to injure her. As a direct and proximate result of defendant t's defamation of plaintiff has been subjected to public scorn, hatred, and ridicule, and has suffered other injury. Prayer for relief. Wherefore, plaintiff prays for judgment against defendants and for the following relief. A, the judgment be entered against defendants for special damages, compensatory damages, and punitive damages in an amount which shall be known to be reasonable and just by the evidence and in excess of $75,000, exclusive of interest and costs. B, that all costs of this action be assessed against defendant, including all reasonable attorney's fees, costs, and expenses of this action. Let me just interject here too that E.G. Carroll has never received a dime of the $80 or $90 million that she was awarded in jury trials. Not a dime yet, and may never. She probably doesn't expect to. And where's the contempt of court? Again, where's the contempt of court? That all costs of, did I go with B yet? I think I read A, $75,000. B, that all costs of this action be assessed against defendants, including all reasonable attorney's fees, costs, and expenses of this action. I think I read that one. C, that an order of protection in favor of plaintiff and all associated with her be issued so as to protect them from harm and harassment from defendants and their agents and associates. And D, such and other further relief as the court may deem just and proper. Jury demand. Plaintiff demands a trial by jury of all issues properly triable by a jury in this action. Dated September 30th, 2016 in Winter Park, Florida. One of the lawyers is Winter Park, Florida. Another one of the lawyers is Princeton, New Jersey. And let's see. This is probably, let me just, skim over the last 10 pages. That was 10 pages. At least it's all double spaced and everything. Otherwise, it would be impossible to read on the cell phone. Status of earlier filed case closed. So that's just about when it was filed prior. Declaration in support of plaintiff's request for protective order. I am a competent adult over 18 years of age to testify. I was subjected to extreme sexual and physical abuse by defendants, including forcible rape that took place at several parties of defendant Little E during the summer of 1994 in New York City at a residence used by defendant Little E. During this period, I was 13 years old. More particularly, I traveled by bus to New York City in June 1994 in the hope of starting a modeling career. Isn't that so sad? Like how many chewed up and spit out. I went to several modeling agencies, but was told that I needed to put together a modeling portfolio before I would be considered. I then went to the Port Authority in New York City to start to make my way back home. There I met a woman who introduced herself to me as Tiffany. She told me about the parties and said that if I would join her at the parties, I would be introduced to people who could get me into the modeling profession. Tiffany also told me I would be paid for attending. So that's interesting. At the Port Authority, the bus station, because I know that perps hang out at places like that in big cities, looking for runaways in particular. Number 4, the parties were held at a New York City residence that were being used by defendant Little E. Each of the parties had other minor females and a number of guests of Mr. Little E, including defendant Little T, Little D, Little DT. At 4 of the parties I attended, I understood that both Little T and Little E knew that I was 13 years old. Defendant Little T had sexual contact with me at 4 different parties in the summer of 1994. On the 4th and final sexual encounter with defendant Little T tied me to a bed, exposed himself to me, and then proceeded to forcibly grape me. In the course of the savage sexual attack, I loudly pleaded with defendant Little T to stop, but he did not. Defendant Little T responded to my pleas by violently striking me in the face with his open hand and screaming that he would do whatever he wanted. Immediately following this grape, defendant Little T threatened me that were I ever to reveal any of the details of defendant Little T's sexual and physical abuse of me, my family and I would be physically harmed, if not killed. Defendant Little E, number 7, had sexual contact with me at 2 of the parties that summer. On the second occasion involving defendant Little E forced himself upon me and proceeded to grape me anally and vaginally despite my loud pleas to stop. I know this is repetitive, but that's how lawsuits are. They're very repetitive. Defendant Little E then attempted to strike me about the head with his closed fists. Oh, I missed that it was plural fists. Yikes. Well, it's bad enough with one closed fist, but 2 closed fists? OMG. He angrily screamed at me that he, defendant Little E, should have been the one who took my virginity, not defendant Little T, before I finally managed to break away from defendant Little E. 8, immediately following this grape, just like defendant little t, defendant little e threatened me not to ever reveal any of the details of defendant little e's sexual and physical abuse of me, or else my family and I would be physically harmed, if not killed. Number 9, both defendants had let me know that each was a very wealthy, powerful man and indicated that they had the power, ability, and means to carry out their threats. Indeed, defendant little t stated that I shouldn't ever say anything if I didn't want to disappear like Maria, a 12-year-old female that was forced to be involved in the third incident with defendant little t, and that I had not seen since that third incident, and that he was capable of having my whole family killed. You know, cars run off the road all the time. For instance, number 10, the duress imposed on me. Oh, and planes crash an awful lot too, don't they? For example, the duress imposed on me by defendants not to ever reveal any of the details of the sexual contact and physical abuse caused to me by the defendants has not terminated, and the fear it has instilled in me has not subsided. Unfortunately, making matters worse for me, I was subjected to daily painful reminders of the horrific acts of defendant little t via mass media coverage of him starting last summer that over a short period of time became continuous and unavoidable. Yeah, can you imagine seeing somebody like that that you had that experience with becoming a world leader? Hey, Patricia Moss, how you doing? Jazzy Zena just joined the live. Happy Wednesday. Yes, happy Wednesday, and Coco is back. If she scratches again, I'll let her in. I think I'm almost done with this. Let's see. I think I'm on number 11. The duress has prevented me from starting litigation before this year. However, as soon as I surfaced, I received threats. More specifically, shortly after my first complaint was filed in California on April 26, 2016, I started receiving threatening phone calls on a cell phone that I then owned. The calls were never for more than 20 seconds or so before they hung up, and they were always from a blocked or unavailable phone number, according to my caller ID feature. Since I changed phone numbers, the threatening calls have completely stopped. Number 12, this litigation involves matters that are highly sensitive and of a personal nature, and I believe that identification of me would pose a risk of retaliatory physical harm to me and to others. 13, let me let the Coco in. Hey, baby girl, here you go. Here's a pillow. Okay, me back. Oh, I set a pillow down for her to lay on, and she laid right next to it. Isn't that cute? 13, I have no reason to believe that the defendant's threats have ever been lifted or will ever be lifted, so I request that the court issue an order protecting me and my family from harm and harassment by the defendants. I declare under penalty and perjury that the foregoing is true and correct, dated June 18th, 2016. So that's interesting that she filed both times in 2016. So what was that, about like April? And then she withdrew it, and then she decided to refile it. Declaration, I, Jane Doe, a pseudonym, state as follows. I am a competent adult. In the 1994-95 school year, I was told by the plaintiff in Jane Doe versus little t and little e that the plaintiff was subject to sexual contact by the defendants at parties in New York City during the summer of 1994. I declare under perjury that the foregoing is true and correct. And that I was so confused because it signed Joan Doe, and I thought it was signed Jane Doe. That's why I was like all like, what? I was like, why is she writing this about herself? Okay, so that's Joan Doe, dated July 23rd, 2016. And then another declaration in support of plaintiff's request for a protective order. I, Tiffany Doe, a pseudonym, state as follows: I'm a competent adult over 18 years old. Number two, I originally met little E in New York City in 1990 when I was the age of 22. This Tiffany Doe is very likely Maria Farmer, in my opinion. I'll have to like match up the dates and the ages, but he didn't really go after people in their 20s, but he went after her and she was in her 20s. And she was initially a Jane Doe. She was under a pseudonym, and then she came out with her real name. So Maria Farmer is the artist who went to the Art Academy in New York City and was assaulted in Ohio, in New Albany, at Wexner's property. Her little sister was assaulted at the Zorro Ranch in Santa Fe by little E and Ghislaine, and allegedly, I guess. And then Maria Farmer has overcome brain cancer twice. I think she's in her 40s now. I could do a little math and figure that out. If this is her 1990, age of 22, that would be 35 years ago. Would that make her 57 now? Yeah, that would make her about my age. 1990, age of 22. I was 23 in 1990. I don't know if she's my age. Maybe this isn't her. I'll just check it out. Anyway, let me finish reading. Sorry. I originally I still think it's probably her. I just didn't realize we were the same age. Oh, and Virginia Gouffre and I share the same birthday, not the same year, but the same birthday. I just saw that yesterday. I was like, OMG, how did I miss that all this time? I originally met Jeffrey little E, in New York City in 1990 when I was 22. I attended a series of parties that same year in 1990 where I was paid to entertain various guests of Mr. Epstein. In the year 1991, I was promoted to the occupation of party planner, in which my duties were to get attractive adolescent women to attend these parties. Yeah, it might not be Maria Farmer, because she was like assigned to be like the desk person to register all of his victims as they came into the house. And then she was hired to do custom art. That's when she went to New Albany for a summer. She was going to be doing custom art. I think she also went to New Mexico, but I think they featured her art in the movie As Good as It Gets, and that that was through a connection with little E and Les. I believe that was probably like the summer of 94. I don't know. I should look up the year of that movie, As Good as It Gets. Let's see. Write that down because I'll forget, and then I'll be like, what was I going to look up? Don't you do that a lot? Like you get to your Google, then you're like, wait, what was it? Okay. Party planner. Okay. 14, I was hired by and paid directly by little E from the years of 91 to 2000 to attract adolescent women to attend these parties, most of which were held at what is known as the Wexner Mansion, located at 9 East 71st Street in New York City. In June 94, while performing my duties as a recruiter of adolescent women to attend Mr. Little E's parties, I met a 13-year-old adolescent woman, the plaintiff in this matter, at the Port Authority in New York City, who said she had come to New York in the hope of starting a modeling career. Yeah, see, with these witnesses too. So, yeah, this is the one that scooped her up from the Port Authority. Number 16, I persuaded the plaintiff to attend a series of parties with little E that took place during the summer of 94. I told her that if she would join me at the parties, she would be introduced to people who could get her into the modeling profession, and she would be paid for attending. And this is just like Sean Combs and his luring people with the promise of a musical career, and R. Kelly too. It was at these series of parties I personally witnessed the plaintiff being forced to perform various sexual acts with little t and little e. Both little t and e were advised that she was 13 years old. Yikes. Number 18, or no, number 8, sorry. I personally witnessed 4 sexual encounters that the plaintiff was forced to have with little t during this period, including the 4th of these encounters where little t forcibly graped her despite her pleas to stop. 9. Wow, this is crazy, isn't it? I personally witnessed the one occasion where little t forced the plaintiff and a 12-year-old female named Maria to perform oral sex on little t, and witnessed his physical abuse of both minors when they finished the act. Sorry. Trigger warning again. I told you this whole thing is like perverted. Number 10, I personally witnessed or was made immediately aware of the 2 occasions where my boss, little e, attempted to grape and sodomize the plaintiff. I personally witnessed little e sexually and physically abuse other minor females, even younger than her. 11, it was my job to personally witness and supervise encounters between the underage girls that little e hired and his guests. Oh, how awful. 12, I personally witnessed little t physically threaten the life and well-being of plaintiff if she ever revealed any details of the physical and sexual abuse she suffered by her at the hands of little t. 13, I personally witnessed little e physically threaten the life and well-being of plaintiff if she ever revealed the details of the physical and sexual abuse she suffered at the hands of little e or any of his guests. 14, I personally witnessed defendant little t telling the plaintiff that she shouldn't ever say anything if she didn't want to disappear, like the 12-year-old female Maria, that he was capable of having her whole family killed. So Maria must have been eliminated, huh? Or maybe just in a tunnel on an island or something. I don't know. Like a baby farm. Who knows? Can't put anything past people like this. 15, after leaving the employment of little e in the year 2000, I was personally threatened by little e that I would be killed and my family killed as well if I ever disclosed any of the physical and sexual abuse of minor females that I had personally witnessed by Mr. E or any of his guests. 16, I am coming forward to swear to the truthfulness of the physical and sexual abuse that I personally witnessed of minor females at the hands of little t and little e, including the plaintiff during the time of my employment from the years of 1990 to 2000 for little e. I swear to these facts under penalty of perjury even though I fully understand that the life of myself and my family is now in grave danger. I declare under penalty and perjury that the foregoing is true and correct, dated June 18th, 2016. Phew, 19 of 19. Let me set that down. That was a little bit exhausting. Not too bad, but hopefully it wasn't too arduous for you guys. If you're still here, it looks like some are. Yeah. When I saw your comment again, Patricia Moss, if you're still here, and it says, hi,